indicated Mr. Merritt wanted to make a statement.
Yes, Your Honor. Yes.
All right.
First, I would like to say I am so very sorry that Joseph's, Summer's, and Joseph Jr.'s family and Gianni's families have had to bear this horrific tragedy. No mother or dad should have to bear this. The pain of losing their son or daughter. No brother or sister should be deprived of a lifelong relationship with their sibling. For a family to lose so much is unimaginable. In this setting, and with the loved one's feeling that they've finally found justice, I'm conflicted in addressing the issues that I have to hear. After hearing your statements and knowing you feel that justice was done here, a part of me wanted to just stay silent, at least for a while. But the thing that is bringing you this solace is ending my life. Ending my life for a crime that I did not commit. I love Joseph. He was a big part of my life and my family's life. I would never have hurt him in any way. I would never raise my hand to a woman or child. I did not do this thing. I know you do not believe this. And that kills me. But I believe that if you were to look deep into what has happened here in this courtroom, and over the last 5 years, you'd have to recognize that something's amiss. Something is wrong. This prosecution team, without any care whatsoever, has used you and others to accomplish their goal. They convinced you. I did this thing. I know that. And honestly, if I lost a son, brother or daughter, grandchildren, to such a cowardly act, and genuinely believed what the detectives and prosecutors were telling me, that we have the man that did it, I would likely do as you have. But Miss Blake, Michael, the things you told the jury that were untrue, they weren't unconsequential. They helped me get convicted. I hope someday you can ask yourself, someday, the question, why would the prosecutor just need these false statements from you if they indeed had the evidence proving my guilt? What you witnessed throughout this trial was fabricated. As I said, I can't feel angry for your participation in my conviction. If I were in your shoes, I might have done the same. I do, however, have the utmost disdain for the people who put us all in this courtroom. This prosecution team, without concern of their consequences, systematically manipulated the evidence in this case to unrecognizable and malicious assault I never would have thought possible. And in doing so, knew the person or people responsible for this heinous act are still free, all to simply get a win. Their theories throughout trial have been a target that moves opportunistically when confronted by contrary evidence. Like when Mr. Imes stated, "I believe the family was not murdered in that house." You'd have to ignore the evidence. Or "I believe the family was murdered in the house." And to not believe that, you'd have to ignore the evidence. And the next day, the following day, Ms. Rodriguez states, "We never said they were killed in that house." These prosecutors resorted to inflammatory rhetoric, brought out inadmissible and prejudicial statements in the guise of questions, suborned perjury, misled witnesses, including you, Michael, and you, Susan. They did these things to keep persistently before the jury the assumption of damaging facts which they knew could not be proven, which they knew were false. Then, of course, there's the court, who let this misconduct permeate the trial. A judge who was so set on ending the trial abdicated his role by telling counsel on both sides he could not stop the trial and have hearings on misconduct because I'm going to let the next court deal with it. What is most troubling, however, is the fact that after my penalty phase verdict was read, the judge still had to decide my fate. As to whether I live or die. Entered the jury's chambers with Joseph's and Summer's family and had intimate contact with them. This prior to deciding my fate in the motion for a new trial as the 13th juror. Indeed, the jury room was full of high fives, hugs, and congratulatory remarks. When I was told of this behavior, which included the court as well as prosecutors, it reminded me of a story I once read of a photographer who photographed a couple of soldiers flashing thumbs up behind a pile of their victims. As he looked on, he said, it was so jarring that for a few seconds he took it for a montage. But yet, there was something familiar about that scene. Then he remembered the last time he had seen a scene like that was in photographs of lynchings. I'm sure this is not the first time anyone or all of these prosecutors have egregiously committed fraud upon this and other courts. They are professional liars and likely have been for the better part of their disreputable careers. Your Honor, there are no second acts. Do what is right. Give me the hearing I deserve. I can show you where this trial has failed. Allow me to show the family just what these prosecutors have done. What's happened here is wrong. It's taking me from my family, a family that does not deserve this. I may deserve a lot of things. I don't deserve this. I did not do this. And as God is my witness, I will be back here and I will prove to everyone that that is true.
Thank you, Mr. Merritt. As I indicated in ruling on the previous motions, the defense has vigorously maintained Mr. Merritt's innocence throughout the proceedings. They have vigorously presented evidence on all of the issues, and the court has reviewed the evidence, and including the defense evidence. And the court, after independently reviewing and weighing all of the evidence that was presented during the trial, reiterates the court finds that, in its independent judgment, that the verdict of the jury is supported by substantial evidence, and the court, sitting as the 13th juror, independently weighing and evaluating the evidence, comes to the same conclusion. So that now brings us to the issue of sentencing. No legal cause, Mr. Moline, why judgment should not now be pronounced?
Your Honor, it's our position that there is still legal cause as to why judgment should not be pronounced. We believe, as indicated in even though the court denied the motion, we still feel that that this court should not be sentencing because there is a bias that was pointed out in our moving papers. So we believe there is a legal cause as to why judgment should not be pronounced by this court. Also, I was presented with a judgment of death order by the prosecution. We would object to it in its entirety. As the court is aware, Governor Newsom on March 13th, 2019 declared a moratorium on California's death penalty. In addition, he repealed California's lethal injection protocol, and he immediately closed the execution chamber at San Quentin State Prison. So any orders to the contrary would be contrary to the law. That was an executive order. It was not a moratorium. That was an executive order. I believe that carries the weight of the weight of the law at least at this particular moment in time. So I would object to any death order that the prosecution has submitted. And submit on that.
All right, well, certainly the governor has the power to grant a moratorium. The governor will carry out his duties and responsibilities as he sees fit, but he did not change or repeal, nor can he repeal the statutory provisions providing for the various penalties. So I will do my duty under the law as it currently exists, and I assume the governor will do his duty as he sees fit, as well as the appellate courts. The court is certainly aware that counsel has requested further hearing on the issue of the sufficiency of the evidence, to the extent that counsel wants to introduce new or additional evidence that was not submitted during the trial to show or demonstrate or argue that the evidence relied on by the prosecution was false, misleading, or out of context. That is not properly addressed in a motion for new trial. The motion for new trial is based upon review of the evidence in the record. Otherwise, a motion for new trial would, in essence, be a new trial. So the court finds that the court having ruled on those issues, there is no other legal cause why judgment should not now be pronounced. Waiver arraignment for sentencing?
Yes, Your Honor.
All right. For the offense of the first-degree murder of Joseph McStay, pursuant to the jury's penalty verdict of life in prison without the possibility of parole, court will sentence Mr. Merritt to the sentence of life in prison without the possibility of parole for the murder of Joseph McStay. The jury, having found Mr. Merritt guilty of the first-degree murder of Summer McStay and the first-degree murder of Gianni McStay and the first-degree murder of Joseph McStay Jr., and the jury, having found the special circumstances of multiple murder to be true as to each of the first-degree murders as to Summer, Gianni, and Joseph Jr., and the jury determining the appropriate penalty verdict to be death for each of the murders of Summer, Gianni, and Joseph Jr. And the court, having denied the motion to modify the verdict of death to life imprisonment without the possibility of parole. It is therefore the judgment and sentence of this court, is hereby ordered, decreed, and adjudged, that for the first-degree murder of Summer McStay and for the first-degree murder of Gianni McStay and the first-degree murder of Joseph McStay Jr., that the defendant, Charles Merritt, be sentenced to death, and that the penalty to be carried out at the San Quentin State Prison in the manner then prescribed by law and at a time to be fixed by this court in a subsequent warrant of execution after the defendant's appeals are exhausted, all in accordance with Penal Code Section 3605. With regard to the additional findings, court finds no motor vehicle involved, court finds no ability of the defendant to reimburse for any of the fees or costs. The court does impose the criminal conviction and court security fee and construction fees. Court orders that specimens of the defendant's blood and saliva be submitted and fingerprints and palm prints be submitted to San Bernardino County Sheriff's Office pursuant to Penal Code Section 296. If that has not already been done, court will impose restitution fines in the amount of $5,000 pursuant to Penal Code Sections 1202.4, 1202.45. The restitution fine pursuant to 1202.45 is stayed. Court will also impose actual restitution of $5,000 for the funeral and burial expenses of Joseph McStay, Summer McStay, Gianni McStay, and Joseph McStay Jr., and actual restitution for mental health expenses for Tracy, and $729 for mental health expenses for Blanche. Court will also retain jurisdiction as to any additional issues of restitution. The defendant is remanded into the custody of the sheriff this time, be transported to the prison at San Quentin, and the warden of San Quentin is directed to maintain the defendant at San Quentin until such time as the defendant's appeals are completed.
Your Honor, is that $5,000 each?
Yes. And people do have the warrant of execution.
I provided it to the court. I can provide another copy if you need one.
No, she hasn't. And the court at this time will sign in open court on the record the judgment of death based upon the jury's verdict and the court's pronouncement of sentence.
Your Honor, if the court could just make the following corrections, since I've objected to the entire document, but there are inaccuracies, at least on my copy. It indicates that January 17th, after defense counsel stated that there was no legal cause, that's an incorrect statement. It's incorrect as to the date, and it's incorrect as to my
Are you
statement.
referring to the probation report?
No, I'm referring to the death warrant.
Oh,
It'd be on page 3, second paragraph.
okay. I'll strike that, page 3.
It's actually on page 2 and 3. It was prepared in anticipation of Friday.
Okay,
Last paragraph on page 2, second paragraph on page 3.
I don't see it on page 2.
It's at the bottom, Your Honor.
Court, is there a motion for new trial modification penalty which was presented by the defense? The motions were denied, that's correct.
Well, it's page 3, Your Honor.
Yeah, page 3 at line 7, I see, where defense counsel stated there was no legal cause why judgment should not now be pronounced. I'll strike that. And court will have stricken that and will initial it and date it. Okay. Yeah, that's what I said. Oh, I thought I said Tracy 3240. Okay. Mr. Merritt, normally at this time I would advise you of your appeal rights and your requirement to file a notice of appeal, but in light of the sentence of death, your appeal directly to the California Supreme Court is automatic. The judgment will be forwarded directly to the Supreme Court, which will start your appeal process. The Supreme Court will appoint counsel to represent you on appeal, and obviously they'll communicate with you with regard to your appeal.
I believe at this time, Your Honor, the court is also obliged under the government code to inquire whether Mr. Merritt wishes to have habeas counsel appointed.
I think that's correct. Although there's some issue now.
There is the issue of availability of an actual attorney to be appointed, but at least the record to reflect the court has inquired, and Mr. Merritt has either accepted or declined the offer of appointment.
So, Mr. Merritt, do you wish in the court to, at this time, appoint habeas counsel for the purposes of bringing any petition or writ of habeas corpus on your behalf?
Yes, sir.
All right. The court will again attempt to appoint the, I forget the title of the
Habeas Corpus Resource Center.
Resource Center, yes, to represent the defendant, Mr. Merritt, with regard to any habeas petitions. Okay, and I think that concludes.
If there's a need to update his pre-sentence credits, the probation report was dated September 27th. I've updated those to 1904.
1904 actual as of today's date.
As of today's date, no conduct credits pursuant to 2933.2.
Record reflect that Mr. Merritt does have 1,904 pre-sentence custody credits as of today's date.
That's it.
Anything else?
No, Your Honor.
Okay, we'll be in recess then at this time.